Later on, that copy which had been forwarded to the clerk of court will ultimately find its way to the National Archives. Kaya pag may hinahanap kang matanda ng dokumento, you can possibly get a copy in the National Archives. The notary public is not required. Basta it's a last will and testament. The obvious purpose is to preserve the secrecy of the will. Okay? Kasi kung mag-iiwan ng kopya sa notaryo publiko, baka masilip ng mga ibang tao yung contents ng will at baka madali ang buhay ng testator. Yung mga hindi nabigyan ng malaki-laki under that last will and testament. Okay. Not just the testator, but the witnesses as well must acknowledge before the notary public. They are not required, however, to acknowledge the will in each other's presence. Hindi katulad ng execution, where everyone must sign in the presence of the others. When it comes to acknowledgement, they can do it separately. The testator can acknowledge before the notary public on January 1. Witness number 1 may acknowledge before the notary public alone on January 2. Witness number 2 may acknowledge alone before the notary public on January 3. Pwedeng kanya-kanyang acknowledgement yan. Presence is not required. Okay. If one of the three witnesses is also the notary public who notarized the will, of course, walang kaduda-duda, that is not a valid will. Because the notary public, who is also one of the three witnesses, cannot dichotomize himself and assume two different personalities. One personality as a witness, acknowledging before himself, this time as a notary public. Okay. That's a little bit mind-boggling. Okay? Hindi pwede yun. If there are four witnesses and the will is acknowledged before one of them, he happens to be a notary public, pwede pa. Because there are three other competent witnesses to the execution of the will, excluding the notary public. Okay. Remember the special rules for people who are under a disability. If the testator is deaf or a deaf-mute, the requirements are found in Article 807. He must personally read the will if he is able to do so. Otherwise, he shall designate two persons to read the will and to communicate to him in some practicable manner the contents thereof. Okay. So, it is the testator who will designate who these two people are who will read the will, assuming the testator cannot read, and thereafter communicate to him in some practicable manner the contents thereof. I have always wondered whether it is possible for a person to learn sign language without learning how to read or write. I do not know if that's possible. So, at any rate, the law, I think, assumes that, well, some mode of communication is possible between the illiterate testator and the two persons who have read it. And while the law does not categorically so state, it is, I suppose, understood that the two individuals will communicate the contents one after the other. Hindi naman pwedeng sabay yung dalawang tao nagkukumpas sa testator kung ano yung contents ng will. Isa-isa lang, mahina ang kalaban. So, yung isa muna, basahin niya, tapos communicate niya, after his through, yung isa naman. Siya naman na magkukumpas doon. Alright. If the testator is blind, tandaan lang natin two readings. Okay? If the testator is blind, the will must be read to him twice. And, you know, the law even specifies who should do the reading. once by one of the witnesses, and again by the notary public before whom the will is acknowledged. If the will is read only once to the testator, sabi ng testator, tama na yung isang basa. Nakababasa lang yan. Babasahin mo na naman yan. Sige na. Tapos na yan. Okay na yan. That's not a valid will. It is not for the testator to waive a second reading. That's a mandatory legal requirement. Okay? Which must be complied with, otherwise the will be invalid. The obvious purpose is to prevent the commission of fraud. Okay. If the testator is illiterate, walang specific provision. But I submit that the same rule should be applied. Same rule for blind testators. Kasi ang illiterate testator, para ding bulag yan. Kahit na ipagwagwagan mo sa harap ng mata niyan yung will, parang bulag yan, hindi nababasa. These are just meaningless signs and symbols insofar as is concerned. So, if the testator is illiterate, the will must be read to him twice. Just like in the case of a blind testator. Okay? All right. You remember, however, the case of Alvarado versus Gabiola, where the testator was blind. The will was read only once. And not only that, it was not read by the notary public nor by one of the witnesses. Ang nagbasa ng will was the lawyer who drafted it. And yet, the will was allowed there. Why? Because while the lawyer was reading the will, yung nagdraft ng will, they were all seated around the table. The notary public was there, the three witnesses were there, and they each had a copy of the will. So, meron silang kopya ng will. So, basa si attorney, they were following his reading, word for word. Sinusundan lang yung basa, kung tama ang binabasa niyan. Okay? After that, the testator said, that is my will. And so, it was signed, it was acknowledged for the notary public. The court said there is substantial compliance. And correctly so. Walang duda. There was substantial compliance with the requirement of the law. Alright. Kasi nandun naman silang lahat, and notary public and the three witnesses were each given a copy of the will, and they were able to follow the reading of the lawyer, word for word. Alvarado versus Gabiola. In the absence of bad faith, forgery or fraud or undue and improper pressure and influence, defects and imperfections in the form of attestation or in the language used therein shall not render a will invalid if it is proved that the will was in fact executed and attested in substantial compliance with the requirements of Article 805. That's the doctrine of liberal interpretation. I think we can have our oxygen break at this point. So let's have a little break.